Well, there are still many unanswered questions surrounding the SNC-Lavalin scandal, including whether this controversy could have been avoided if the roles of Justice Minister and Attorney General were separate. Joining us this morning for more is Executive Director and General Counsel of the Canadian Civil Liberties Association, Michael Bryant. Mr. Bryant, thanks for joining us this morning.
Good morning.
As a setup for our viewers and a reminder, the position of the Attorney General is an independent legal officer whose duty it is to keep partisan concerns out of decisions, so based solely on the law. Whereas the Justice Minister is a political executive who answers to the Prime Minister, like a regular, one of the other ministerials. If Jody Wilson-Raybould had not held both positions at the same time, which has been done in our country since the 1800s, would it have made a difference in how this scandal played out?
No, it wouldn't, because when the Prime Minister and the Prime Minister's office were communicating with the Attorney General about the prosecution, they were communicating with her as Attorney General. So it wasn't like they were putting pressure on her with respect to her Justice Minister responsibilities and forgot for a moment that she's also the Attorney General of Canada. So this would not have avoided that. The main reason for doing it is to, I guess, to give the public some more confidence that that the position is in fact being treated independently, and certainly, I guess, it would eliminate any confusion if people go out to dinner, say the Prime Minister's office and the Attorney General, and they know what they're doing is they're talking about the quasi-judicial business that the Justice Minister does, and not the other way around.
In the UK, this example has been brought up a few times. Those two roles are separate. However, you say the downside is what the Attorney General does has a real impact on what the Justice Minister does and how they operate. Can you explain more on that?
Sure. So if the Attorney General, say, is going to take a hard line on drinking and driving prosecutions on the one hand, then that requires that the Justice Minister has to have more prosecutors in place to effect that policy on the other hand. So the two of them do work together. One does have an impact upon the other. And also, the Justice Minister in the cabinet it's a powerful, or I guess an important position, and historically important position in the cabinet.
We are committed.
How can the Minister and the Attorney General provide legal advice on their own policies, or legal advice that they have a political interest in promoting? Meaning, operating as Justice Minister, you're loyal to the party. Operating as Attorney General, your loyalties lie with the law.
Well, I'm sure most Canadians didn't even know that this dichotomy existed in the past, but it does. And at the same time, what's important here is that people have confidence in the Attorney General role, because the individuals making decisions about prosecutions, sentences, dangerous offender applications in the case of a provincial Attorney General. I think that if we move towards the British system, the downside is that you won't get the kind of person who has been a Justice Minister before and had that political heft. And the fact is that the Prime Minister still has to appoint the Attorney General. So the Prime Minister still has that power over the Attorney General. So any pressure that's brought to bear on the Attorney General will still, in fact, be political pressure that I think is for which people should not have confidence in.
Right.
Because what happens is, if that's happening, then the person, if they're not doing what the Prime Minister wants, then they can lose their job. That's really what it comes down to.
Mr. Bryant, thanks for joining us this morning.
Thank you.